Hello friends, welcome to iExamB's Law Channel Legal B. In this video, we are going to talk about the previous year questions of the paper 2 law paper with solutions. The last management trainee legal exam was conducted in 2017 and we are going to discuss few questions of that exam. We will also try to analyze these previous year questions and I'll also be giving you another important information relating to the law syllabus. First of all, the important dates. The last date to fill the online application forms is 7th of August. So if you are still waiting, you have not yet completed your form, hurry up. The online submission of applications is going to end soon. For eligibility, you need to be a graduate in law of 3 years or 5 years with a minimum of 60% marks. This minimum 60% marks in LLB is a must. If you have less than 60% in LLB and more than 60% in LLM, then also you are not eligible. I have dropped a mail with respect to this to the Coal India and they have clearly mentioned that 60% in LLB is required. The maximum age limit is 30 years as on 31st of May 2022. Let's quickly go through the exam pattern. It is a computer-based test of 3 hours. Paper 1 will have 100 questions of 100 marks from GA, reasoning, numerical ability and English, and paper 2 will have 100 questions of 100 marks from professional knowledge, that is your law. There is no negative marking and there is no interview in this exam. One of our students has dropped a mail related to the syllabus of paper 2 to the Coal India and they have replied that regarding paper 2, generally speaking, syllabus which is commonly followed in the qualifying examination at university or institute level and required for a particular post will be the guiding syllabus for CBT for recruitment of MTs in CIL. This syllabus cannot be construed as exhaustive. For example, for MT Legal, the syllabus followed for LLB courses in different university or institute etc. will be the guiding syllabus. Now in the university and institutes, there is no coal laws or coal mine laws. So from this we can infer that they may not be a part of the syllabus. I have discussed the syllabus earlier with you. In 2017 recruitment, in the syllabus there was IPC, CPC, CRPC, evidence, constitution, contract, specific relief, court fees act, negotiable instrument act, registration act, transfer of property and limitation act. In 2017, the syllabus was released after the last date of the application form. So we are expecting this year also we will get the syllabus after 7th of August. Then we can surely say whether these will form the part of the syllabus or not, whether the syllabus will include labor laws or not. But one thing we can say that coal laws, mines laws may not be present in the syllabus as per the reply to the email that we have got. Now going through the 2017 question paper analysis, we were able to retrieve few questions, not the entire paper, and based on that we were able to understand from the CPC there were 9 questions, from CRPC there were 9 questions. There was one question related to the case law of intellectual property about the patent laws. Then there were 9 questions from IPC, 8 from Evidence Act, 8 from Contract Act, 7 from Transfer of Property Act. From specific relief there was only 1. From Constitution there were 13 questions. One was from the IT Act, that Shreya Singhal case, which was in violation of Article 19 of the Constitution. There were 5 questions from negotiable instrument, 2 from registration, 1 from court fees. These were the questions that we were able to get. Apart from that, there were some other questions. They may be from these acts or from other acts. So we will have to wait for the syllabus to get for sure. But from these 73 questions, around 18 questions were on case laws. So you can see a major chunk of the questions is from case laws. Judgments are really important for this exam. We at iExamB are providing Coal India MT Legal online course in which we are giving live classes, practice tests, mentoring, study material PDF, and we are soon going to add all the important judgments to these PDFs. As of now, you can get PDFs with respect to all the important acts and a lot of practice questions. And at present, we are giving a flat 50% off on this course. So if you are interested, check out the demo from the description below. Use COAL50 coupon code to avail 50% discount on this course. This is the previous year paper of 2017. You can find the PDF of this paper from the description below. you can find detailed explanation of every question. The first question talks about section 115 of the Code of Civil Procedure, and very direct question, what does it deal with? The power of revision lies with trial courts, district court, high court or supreme court. Under section 115, the power of revision lies with the high court. Then the second question is from section 6 of the Specific Relief Act. If you go to the third question, the historic judgment of Privy Council in Pakala Narayan Swamy versus the King Emperor deals with. Though this case deals with two issues, but in the question paper the answer was given as confession. However, according to me, the correct answer should be both A and B. It talks about both the dying declaration and confession, and I have given a very elaborate explanation to understand the entire concept of this case law. There were two issues that were discussed in this case: whether the statement of the accused can be considered as confession, and whether the statement of the deceased to his wife that he was going to Behrampur to take back his loan was considered as dying declaration or not. And then I have given you the stand which Privy Council has taken with respect to confession and with respect to the dying declaration. So download this PDF and refer to the solutions that are present. The fourth question is again very direct. Nothing is an offence which is done by a child under 7 years of age, that is present under section 83 of the IPC. It is also dealt with the legal maxim dole in capax. In this way, you can find explanations to all the questions, detailed explanations to understand the entire concept. I'll just show you another case law, how we have tried to give you answers to the case laws for clarity purpose. For example, consider question number 29. In which of the following cases the Supreme Court of India has held that mere fact that a witness is inimically disposed towards accused person, that is, he is a hostile witness, cannot by itself be a ground for total rejection of his evidence? And the correct answer is Sadhu Singh versus State of Uttar Pradesh. Now, why A, C, D are not the answers? We have also tried to discuss that in the explanation. In Sadhu Singh versus State of Uttar Pradesh, the law is settled that the evidence of hostile witness cannot be rejected outright. Both the parties are entitled to rely on such part of his defense which assists their case. Then in another case which is given in the option, in Anil Sharma versus State of Uttarakhand, the admissibility of extrajudicial confession was discussed, and certain points were given that when extrajudicial confession can be relied upon, where extrajudicial confession is usually a weak evidence by itself and it should be taken by the court with great care and caution. Then another case in the option is State of Karnataka versus Yarappa Reddy. Here the Supreme Court held that investigating officer can refer to the records while giving evidence in court. This deals with section number 153 of Evidence Act, that is refreshing the memory, whether the investigating officer can refresh his memory or not. There is nothing wrong if the trial court has permitted the investigating officer from the police department to refresh his memory by referring to his investigation records. So in this way, you will find a detailed explanation to the questions that came in the 2017 question paper. Some of the questions are very direct. So my general observation from all this is that there were a lot of questions from section numbers. The section numbers become important apart from the facts based questions. Another thing was, a lot of questions were there from the recent amendments, Criminal Law Amendment Act, Negotiable Instrument Amendment Act. Third one is, there were a lot of questions from landmark judgments and recent judgments. Some of the famous landmark judgments were included in question. Other than that, since the paper was in 2017, there were few questions from judgments of 2016-17, especially from the criminal law. So these are very important. You have to refer to all the landmark judgments and recent judgments. As I was mentioning, in our online course, we are going to provide all the important judgments from the exam point of view. If you have any queries, you can write in the comment box. You can also write to us at hello@iexambee.com. You can call us on the number mentioned on the screen. Subscribe to Legal Bee channel to stay updated with such information. Thank you.